Okay. Go.
You hand me my screen box. Now go. Freak.
Good afternoon. Are you Giovanna Reyes Apollino?
Yes, that's me.
Good afternoon. Has this defendant been served? I don't have a proof of service.
Yes.
Do you have that in front of you?
I took a picture of it. I left it at the door because you did not open the door.
Well, you have to have a process server serve it. I'm not sure that you exactly know what you're doing here. I'm not sure this person's going to show up. If they do show up, that's great, but I don't think you have legal proof of service.
I sent
Do you
it
have a
on.
do you have a lease?
I had a 1-year lease with her, but then she stayed, and we just never renewed the lease.
Well, I don't have the existing lease. A copy of it.
I was told that I didn't need one.
Told by who?
When I went to the courthouse.
You got a $50 per week late fee. The law doesn't allow that much of a late fee. Is this tenancy month to month or week to week? Is it $1,000 per month?
Yes, and it includes all the utilities.
Well, you can't do a $50 a week late fee.
I never charged her for it.
Is it in the lease?
Yeah, it was in the lease.
But now you don't have a lease.
No, I don't have the lease.
The other problem is this a month-to-month tenancy and you gave her a 7-day notice to quit. And so she's entitled to a full rental period. On January 12th, you told her she had to move within 7 days. And this is a month-to-month tenancy.
She had already not been paying. I had told her since before, for 3 months before that, she did not pay. And I had told her if she wasn't going to pay, that she had to move out. I officially
Okay,
served.
well, let me say this. The rules are complicated. And they
Yeah.
got more complicated in November. And the landlord is assumed to understand the rules, even more than the tenant. And you can get sideways if you don't follow the rules. You could use some legal help. You could use someone to draft a proper lease for you. You could use someone to teach you how to file a proper proof of service. Your notice to quit has got problems because it's a 30-day notice rather than a week-to-week notice. So, and then you did file the fee for supplemental damages. I don't think they're going to show up because I don't think we have proper service. And I can't do a default unless I've established that they were properly served with the case. And you can't do it. What you put on her door is a notice to quit. Service for court has to be served by a court officer.
All right. Well, that paper
Well,
I called the courthouse, and then that's the one that they told me to print out over the phone. So then I just printed it out at home, and they told me basically fill it out and then follow the instructions on the paper.
like I said, you could use some legal advice from a lawyer, not from a clerk. And I'm not sure what they said, but let's calculate right now how much you say the rent is behind. How much rent is due through February?
Through February, I had written it on there because it'd been a couple months, and then she did pay some weeks.
Well, I'm going to ask you this every time. How much does she owe? How much is late fees? How much is rent? She owes you $1,000, $630 plus $1,000 in late fees. So through January 22nd. Now, this is a unit in an apartment building?
Yes, it's a house, and it's 3 units in the house.
And you charge $1,000 for a piece for the apartments?
It's a 2-bedroom, one bathroom.
Well, if you can get it, more power to you, but
Well, I'm
that's
including utilities in that. She doesn't pay anything.
okay, yeah, I suppose. All right, well, we have multiple problems. One, the defendant isn't here. Two, you haven't properly served her and filed a proof of service with the court. Three, your notice to quit doesn't fit the case. It's a month-to-month tenancy and you filed a 7-day notice to quit. Four, I can't tell about these $50 per week late fees. Hey, you can't, if it's not in the lease, she doesn't have a lease, you can't do any late fees.
Okay.
And I can't exactly tell how much rent is due. You say she hasn't paid in several months.
Yes.
Well, the rent is $1,000 per month.
Yeah.
And
she stopped in December. Well, before that, she stopped paying, but then she paid some of it. So she made some of it. And then in December, she completely like ghosted me and wasn't paying anything at all from the old back rent and then current rent.
So in addition, you're paying her utilities.
Yes.
Well, I can't do a default because she wasn't properly served. There's a bunch of issues here, but at least if she was served, we could try to address some of them. Let me repeat, you could use some help from an attorney. You don't have to, but we can't give legal advice at the court. And I don't know what the clerk told you, but either you didn't understand it or they didn't explain it very well. But I'm going to adjourn this until March 18th to allow you to get time to get proper proof of service on the defendant.
Well, she just moved out too.
Oh, she moved out?
She moved out.
Oh, okay.
So I would have no way of getting a hold of her or anything. I had sent her what I posted at her door. I had sent it to her also on Messenger because she changed her number, so I didn't have her current number. The only way I could get a hold of her was through Facebook Messenger. So I had sent her that. So she knew that, at some point she was going to get paperwork.
Well, that may be actual notice, but it's not legal notice. I'm going to dismiss this case. What I would recommend you do at this point is if you want to sue her for money damages, you file a small claims case. That will be simpler. The rules of evidence don't apply. The rules of procedure don't apply. But I'm going to dismiss the case because there's no service and defendant has moved. You can file a case here at the courthouse again in small claims court. You can sue for up to $7,000 in money damages. The rules are much more relaxed in small claims court. And it might be easier. Now, getting a judgment is a lot easier than getting any money, but that's my suggestion. Anyway, I'm going to dismiss this case. Defendant has moved and no proof of service. And if you wish to file a small claims, you can come here to the court. I'm not trying to be unkind, I'm trying to be helpful, but if you're gonna be in the landlord business, we've also got a local landlords association. There are a number of people in Sturgis that are in it, Mr. Kreitz, the Richmonds and Three Rivers, maybe 40 local landlords are in the local landlords association. They're very helpful to each other. I meet with them about once or twice a year at a dinner meeting and go over changes in the law.
Okay.
Anyway, I'd recommend those two things, but this case is going to be dismissed. I'll do the order of dismissal. And if you want to seek money damages, you can go to small claims court.
All right.
All right. Thank you.
Judge, I'll get out of your hair unless you think there's a defendant that might.
No, that's all my landlord tenant. I don't know if you see as many of those uneducated landlords. They sort of stumble into the landlord tenant business. If she's getting $1,000 a month for 3 units in that house on Maple Street, she's doing pretty well, but she could use some help. Well, then let's talk about Mr. Werber's case. This is credit acceptance versus Jennifer Birch and Jeremy Fordyce. Can you hear me?
Yep.
Yes.
All right. This is a claim for quite a bit of money, $13,270.31. The plaintiff has requested a motion for summary disposition. Mr. Fordyce filed an answer saying he could only afford $10 per month.
That changed.
The problem is the interest on a debt of this size is probably several $100s a month, at least $100 a month. So at $10 a month, you just get farther behind. So let me explain what a motion for summary disposition is. Mr. Werber's law firm, Werber and Olsees, one of the leading collection companies in the state, they filed a motion for summary disposition under the court rule, asking for $13,270.91 plus court costs of $310.21 for a total of $13,581. They allege that there is no material issue of fact. You incurred this debt and the debt is due and owing and there are no defenses. They also contend that you filed an answer, but you haven't stated any defense. You simply acknowledge the debt, but indicate that you don't have enough money to pay it. And that certainly is tough. But the fact that you don't have money to pay the debt is not a defense that you owe the debt. Now, this had to do with the purchase of a motor vehicle through Rainbow Motor Sales in Coldwater. And I get a lot of these. People buy a car, the interest rate on this purchase agreement was 22.99%, very high interest. And you bought a $15,000 car and you paid $10,405 worth of interest. So the total loan was $27,000. And at some point, the car gets repossessed, there's a remaining debt owed, and they try to collect it. So summary disposition is familiar to lawyers and judges, but not to lay people. They simply state there's no material issue of fact and you haven't stated a defense. Now, the fact that you don't have any money, if you don't have any money, you don't have any money. They can't pry the gold fillings out of your teeth or take your firstborn child. But if you are working, they can garnish your wages. They can pursue other attempts to try to collect on the debt. But I will tell you that $10 a month on a debt this size, none of us would live long enough for it to be paid off. And it would actually just be worse each month.
I looked to negotiate that, sorry.
Go ahead.
I looked to negotiate with that
All right, well, what I'm going to do is I'm going to grant their motion, and then you can discuss this with the Weber and O'C's law firm and see if you can come to some sort of payment plan. Are you working somewhere?
yes,
Do you both work?
yes.
Where do you work, Jennifer?
I work security. I do security, but I don't get paid a whole lot. I get paid $13.50 an hour.
All
So
right. And where do you work, Jeremy? So both of you have a job that pays wages, and as such, that could be subject to garnishment. And you don't want garnishment because it'll take a substantial portion of your net. It leaves people without enough money to pay the light bill or put groceries on the table. So I'm going to grant the motion for summary disposition, and then I would propose that you discuss this with counsel, see if you can come up with some sort of an amount to pay on this. People are struggling right now, to be sure. Mr. Werber, would you be willing to talk to the defendants in the breakout room as long as everybody's here?
Of course, absolutely. The one thing I'd ask, Judge, since Jeremy only filed an answer and Jennifer didn't, I believe you have an order in front of you, order for summary judgment, but it doesn't have Jennifer's name on it. I don't know if you could just write Jennifer's name in, or do you want me to submit an amendment?
No, I'll just add Jennifer's name.
Okay, perfect. And then Jennifer and Jeremy, I'm happy to discuss this with you. The one piece of good news I can share with everybody is I think it looks like they had to stop accruing interest on this. So that number that's going to enter as a judgment, at least everything you're paying every month is going to go towards that number, and it's going to start coming down. But we can discuss that further. I have numerous options for you to resolve this.
Was that her name when all this started?
yeah.
It was Jennifer Birch. Yeah.
Okay.
It was Birch at the time.
I'm fine, man. All right.
The total is $13,581. All right, I'm going to put you in a breakout room. You don't have to get to the finish line here today, but you can at least start to discuss this. Those are always tough when you're paying for a car that you've paid too much for, that you no longer even own. All right, we are still on the record. We've returned in the matter of credit acceptance versus Jeremy Fordyce and Jennifer Birch Fordyce. They've had a chance to speak in the breakout room. Mr. Werber, what's the status?
We had a great conversation. I provided them with numerous options on how to resolve this. They're going to talk about it. They're going to try to come up with some money and see what they can do on their end. They have my direct dial, so they can reach me. But like I said, I appreciate you allowing us to talk in the breakout room, because I think we certainly had fruitful discussion.
Very good. Mr. and Mrs. Fordyce, do you have any questions?
No, not at this time.
All right, you're free to go.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. He's going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no faith in that. And trust me, out of the day, I'm sitting up here,